Hello everyone, this is Shrishti Baranwal, an intern at ubAdvocate. Today my topic is Introduction to Insolvency and Bankruptcy Code 2016. Insolvency and bankruptcy is a state of being insolvent and bankrupt respectively. People often find insolvency and bankruptcy embarrassing and disgraceful and treat them as unmentionable. A business cannot be a victory most of the times, but it should not be considered shameful. In period between 2008 to 2014, RBI drew attention to a very high proportion of non-profitable possessions, which was consequence of random lending by bank. This made government appoint a joint committee of parliament on 28th day of April 2016, which recommended the IBC. IBC is the most important modifications. Nowadays, if there occurs a default in making payment by debt owed by the corporate debtor, then the financial creditor, operational creditor, and the corporate debtor itself as a corporate applicant can make application before the adjudicating authority. Adjudicating authority are of two types: National Company Law Tribunals and Debt Recovery Tribunals. NCLT, that is National Company Law Tribunals, is for companies, LLPs and other body corporates, whereas DRT, that is Debt Recovery Tribunal, are for banks and financial institutions. As soon as the application gets admitted before the adjudicating authority, an IRP, that is an interim resolution professional, will be appointed and the authority will announce a moratorium period for the corporate debtor. During this moratorium period, the company will not be allowed to carry out its work and will remain suspended. The RP will further constitute the committee of creditor, which include financial creditor and the operational creditor in certain cases. Usually only financial creditor have voting rights. The purpose of creditor is to make a resolution plan within a period for bracing corporate debtors. As per the IBC, we can say that CIRP can be initiated by admission of application under section 7, 9 and 10 before the adjudicating authority. Now the question arises, who is eligible to make an application before the adjudicating authority? CIRP can be initiated by financial creditor under section 7 of the IBC, operational creditor under section 9 of the IBC, and corporate debtor, that is as corporate applicant, under section 10 of the IBC. I would like to conclude by saying that IBC was formulated to mend the relationship between the company and the creditors. The clear intent of IBC is resolution but not liquidation. From this video, one can get a clear picture about the process of initiating CIRP and thus can play an important part in changing the status of CIRP, of IBC and CIRP in India. Thank you.